Have you ever procrastinated launching because you're worried someone might steal your course, or you're just not sure what legal pages that you actually need? Today, we're clearing up your biggest legal questions when it comes to online courses. You're listening to the Online Course Show, where we bring you the insights and strategies to build a thriving course business. I'm Jacques Hopkins, and over the past 12 years, I've built a successful online course business teaching piano that's brought in over $4 million. And I'm here to share the lessons I've learned along the way. Today, I am joined by Bobby Klinck. He's a Harvard Law grad that is now helping course creators navigate all things legal when it comes to their course businesses. In this episode, we dig into your top legal questions and answer them in a way that you will understand. So things like, do I have to start an LLC? Privacy policies, getting someone to agree to terms when they buy your course, copyright, trademarks, and so much more. Plus, Bobby is a course creator himself, and you'll hear how his first launch completely flopped and the takeaways that he got from that. If you finally want legal clarity for your business, this one's for you. Let's get into it. Hey, Bobby, welcome to the Online Course Show.
Hey, thanks for having me. I'm excited to be here.
My pleasure. Let's start this way. So obviously the audience is course creators, aspiring course creators. You know that niche, you know those type of people. What would you say is like the top legal question you get from those type of people?
So the top legal question I get is actually the wrong legal question, but I'll give it to you anyway. The biggest thing I get asked by course creators is, how do I stop people from stealing my course? That really is the thing that people ask me over and over and over again. And I mean, I can give you some pointers, but really, you can't prevent someone. You can't prevent the really bad people from stealing your course and putting it up elsewhere. I mean, a true story. In my prior iteration of my business, I actually sold legal templates, and I had a pack where you could get all of them. You can still go onto sites that purport to let you buy it for like $65. I mean, someone literally just copied my stuff, copied my paste, and they're trying to sell it there. And, that happens, and you're never going to avoid that. So I kind of tell people what you need to do is focus on the things you can control, not the things you can't control. And to some extent, just accept you're going to have some theft of your content. It's just part of doing business.
I love that. I love that you said it's the wrong question, because I'm not a legal expert, and that's one of the big questions I get as well. And it's especially, I get it way more from people that have not launched their course yet. Right? I rarely get that from people that have launched their course making sales. It is a common objection or question people have as they're going through the process of building an online course business. I asked my clients to give me any legal questions they had for you to ask you today, and I'm gonna get to that at some point. And that's one of the questions. That's one of the questions. How to safeguard against competitors going through your course and stealing your content or ideas and then asking for a refund. Yep. And the Bobby answer is, you can't worth worrying about.
Yeah. And again, I mean, the funny thing is that really brought this home for me. This is a long time ago in online world, but back in 2019, I was at Social Media Marketing World, and it was at a lunch at some point, and there was just an area where you could sit, and there was a table that said course creation or something like that. So I said, oh, just go sit there. And I sat there, and one of the people who was sitting there was one of the executives at Teachable. And he started talking to people. He was involved in some of what are called the DMCA takedown notices. In other words, if someone does steal your course, puts it up on a platform like that, you can go through a process, tell them, hey, that's my copyrighted course, take it down, and they'll do it. And he said that when he has done that, over 95% of the times that he's looked at the stats, the stolen course has made 0 sales. So it's not even impacting you most of the time anyway. And he said he'd never seen one that had made more than a couple sales. So it's just not something that's even worth thinking about, because yes, people are going to do it. And again, I always like to say, depending on your price point, but let's say you're selling a course for $1,000 and someone rips it off and is selling this thing on one of these really shady websites for $100. Guess what? Anyone who was going to pay $100 for that, they were never going to buy your course from you for $1,000 anyway. So, Now, again, you don't want the bad news of like they have support issues and they think it's you, but that's kind of a separate issue, but you're not really losing clients out of the deal.
Couldn't agree with you more there. All right, so let's talk about who you are and who you help today, right? So are you this big time attorney, or what do you do today?
I have all the credentials you'd want from a big time attorney. Graduated Harvard Law School back in 2002. Got to work for a year after that, working for a federal court of appeals judge who President Clinton twice considered for the Supreme Court. So he was kind of up at that upper echelon. Then I worked at big and prestigious law firms here in Washington, D.C., where I am now. And at one of those firms, my mentor was this guy at the time. I just called him Neil. At this point, I would have to call him Supreme Court Justice Neil Gorsuch. So, I mean, kind of that was the echelon of lawyers that I was around in my early career. The problem is fundamentally, I'm a punk rock kid from deep South Texas who resonates way more with normal people than these kind of upper echelon elite people. So I made a change in 2010. I joined a small law firm, and it was kind of on a hope and a prayer. They were just two guys at the time. And I think I had an agreement, but it was a firm that did contingency fee work. So, only got paid when we won a case, and we were handling really big cases. So I would go 6 months without getting pay. And then I'd get paid. But it was, they treated me fairly. But then my wife got pregnant in, I guess this would have been 2013. And I said, hey, got to kind of formalize this agreement, actually make me a real partner. And what happens, and what always happens in this situation, is because we hadn't worked it out in the beginning, we couldn't come to an agreement. And so I ended up going out, hanging my own shingle in early 2014, started my own law firm. And at that point, I had a lot more time than I had clients. So I fell into this online marketing world. And it was this weird thing. I got HubSpot certified as an inbound marketing expert back in 2014 or 2015. Again, because why not? I mean, what else was I
as most
do?
Harvard law graduates do, right?
Right. Why not? Right. I mean, let's just do it. And so I did that. And, I built my firm for a while, but in 2016, 2017 period, I just wasn't happy. I was working with a life coach. We worked through all the relationship stuff, all of those issues. And then she basically said, okay, do you like what you do for a living? And for the first time ever, I admitted to someone other than maybe my wife that I didn't. I really didn't enjoy it. And it wasn't that I didn't enjoy the law. It's that I dealt with lawsuits, which meant I spent all day, every day fighting with people about some of the stupidest things ever. There was a time I had to fly down to Florida to argue before a judge that the other side had to give me legible copies. Literally, document would moved as it was being copied, and so it wasn't legible. And they refused to go back and recopy it. And I had to fly all the way down to Florida to get a Florida judge to order them to give me that. And I mean, that's the kind of stuff that I was like, why is this my life? And so this life coach said, okay, what are we going to do about it? I always say those darn life coaches, they won't just let you ruminate. They always make you take action. And so she kind of said, I could see you going on to podcasts, going on to radio shows, talking to entrepreneurs about legal stuff. I said, that's interesting. I'll think about it. Well, by the time I had the next call with her 2 weeks later, I had signed up with back then an agency to get me booked on podcasts. And I mean, this would have been in early 2017, I think. And so I went full bore. I went in and did it. And it's funny. I mean, the pictures I used to send to those people, the headshots, was like me in a suit still, which is funny because now I have a suit. I don't know where it is, but I just don't do it. But that was the start. And 2017, I like to say, was my year of failure. I spent about $60,000 to $70,000 between everything I did that year for podcast management, for training on ClickFunnels, for Facebook ads, a Facebook ads manager, all towards building up and selling a course called Safeguard Your Online Genius. And I did it. And I practiced that webinar. I mean, I used the Russell Brunson perfect webinar frame, did the whole thing. I practiced it. I got done. I said, man, that was awesome. And then I opened it up. No sales. I was like, wait, what? What just happened? I ended up making one sale during that launch. And she asked for a refund on day 29 of a 30-day, no questions asked refund policy. And so I ended 2017 having spent all that money and made $0 in revenue. I was about to quit. Quite honestly, I was about to be done, but I said, you know what? I'm going to give it one more try. 2018, I joined Marie Forleo's B School, and I did it through Amy Porterfield as an affiliate. And so I was in this Facebook group with 1,000 other about entrepreneurs who had joined through Amy's affiliate link. And I just said, you know what? I'm just going to start being helpful. And so I started being helpful and just answering questions. And quite honestly, there's only so much I could help because most of the time people weren't asking me or asking questions about legal stuff. When they did, I would ask. But I also found, hey, I knew stuff about marketing because I had been kind of trying to do it for a while. And so I would answer those questions, and I just got to be this uber helpful person. And for those of you who don't know what was going on in 2018, that's when GDPR, this big privacy law in the EU, was going into effect. And it became this big thing while I was still in this group, and not even in the group, but people would just ask me, well, how do you, what do we have to do? And I didn't want to have to like train people on it. So I was like, let me go find a good training. I go to try to find a good training, and I would watch them, and it made my head hurt. I was like, how the heck is a regular person who's not a lawyer supposed to understand these trainings? And so I decided to create one on my own. And I did, and offered it for free. Most lawyers at the time were charging people for these, and I did it. And that was kind of something that really got me started because Amy Porterfield heard about it. She wanted to have a training. So she brought me on to her podcast. And at the time, I think I had 150 people on my email list, and it grew to 4,000 almost overnight because it was such a big thing. And that was the start. And since then, I've been in this space helping people with the legal stuff, learned a lot of lessons along the way about business, about marketing. Actually wrote an Amazon bestseller that has nothing to do with the law called Email Marketing That Doesn't Suck. And I've done pretty much all the things that your listeners are doing and are trying to do in building an online business along the way.
Man, when I came across you a couple weeks ago, I was like, his name sounds so familiar. And I bet that's why. I bet I listened to that podcast episode back in 2018 when I was trying to figure out the GDPR stuff. That's so interesting.
Yep. Yeah. And she then had me, like, I did in addition to that, I did like a guest training. I was a guest teacher about legal stuff for her course program for a while. That was kind of my rise to prominence. And the big thing I learned along the way during that process was that really being myself, and just adding kind of my own kind of brand of wacky along the way was really what would propel my marketing. So that's where I stopped any sense of being stuffy. I stopped any sense of pretending that I liked wearing suits or any of that stuff because I never have, and just started being me. And so, I credit a lot of my success to that early, I say it was luck. I mean, I just happened to do the right thing in the right group at the right time. But all of us have a bit of luck, but I think I probably was doing some things right along the way too.
There were obviously things you weren't doing right when you made one sale on that first online course and that one sale got refunded. It sounds like you were doing plenty of things right. I mean, you're following the perfect webinar script and all of that. Why wasn't that selling?
Well, I think there was a lot of problems with it. One, I didn't really niche down far enough at that point. At that point, I was like talking to business or to entrepreneurs broadly. And it would have included course creators, coaches, the people who are now my bread and butter. But I also had some messaging there that was talking to tech people and more traditional startups. And if you think about it, the legal stuff is very different between those two types of businesses. One, if you're on the tech side, you're going to have to think about patents and those things way more. And in our side of the world, you're not going to patent anything in an online course. And so there was just different things there. Separately, the Facebook ads manager that I hired, looking back, made the mistake of just trying to get the cheapest leads possible. And what I mean is, I don't remember. I think the lead magnet I was using at the time was like if I remember right, it was like a stock image guide, like what to look for in the licenses of a stock image site to make sure you were okay and could use it. And I didn't realize enough at that point to even know what I was doing wrong. But a lot of the people that she got on my list were photographers. Well, photographers, that's the absolute wrong side. I mean, they were not the people going to buy it, but those were the ones who were bringing in dollar leads, which again, the notion of dollar leads now, I mean, I don't know that you're going to get those anywhere, but definitely not in our space. But, we were getting these really cheap leads and they just kept putting more and more of the budget to that rather than to the other people. Candidly, the offer also wasn't right. One of the things I really discovered over time was that when it comes to legal stuff, people don't want to buy a course. They just want a solution. I mean, they don't want to learn this stuff. They just want the solution. And so that's why in 2018, I shifted to essentially, I was just selling templates. I was selling the legal templates that solved your problems, not a course. Now, I had recorded a lot of training. So I had that course and I said, you know what, I'm going to give it away for free. At the time, it was called the Online Genius Academy, I think, or something like that. But I just gave that away for free. I said, hey, anybody wants to learn this? Great. But candidly, most people didn't. They just want the solution to legal stuff. And so, there were a lot of key learnings there. The funny thing was my life coach, after I had that, she said, oh, well, you made a sale. That's actually good. A lot of people don't make any sales the first time. I was like, why didn't you tell me that before? That was kind of like, that would have been useful information up front, not after I'd, done a typical Bobby thing and had kind of gone all in, which, I always like to say a lot of people like to swap stories of failure and their failed launch. And, I've yet to meet anyone who can match mine, but that's just because I tend to be dumb and go all in on stuff sometimes. And that was an example of it.
Yeah. I mean, the way it happened for you is worse almost than making zero sales, because you got the one, so you're hyped up a little bit. I always say the first sale is the hardest, but then that person bought it, waited a full 29 days, probably saw the inside and decided once they saw it, they wanted their money back, which I'm sure was demoralizing at the time.
Well, the funny thing is I remember looking at the stats. They never logged in. This person never logged in, never looked at it, just decided she didn't need it. But I mean, a lot of people would have been demoralized. I was actually kind of happy because, okay, so I don't have to actually fulfill this thing at all. I can just kind of say, okay, I can put that aside. And so the funniest thing though, is there's a lot of remnants in my business, even to this day, that go back to that. So that course was Safeguard Your Online Genius. Well, my business, my actual LLC is Your Online Genius LLC. And for a long time, people would see that and think that I was saying that I was the online genius. I'm like, no, it's the opposite. I was like, Safeguard Your Online Genius, but it was just this funny little thing that people, didn't even get. And so for a long time, then when I sold templates, it was the Online Genius template library, which is where you get everything. And so we kind of kept that branding for a long time. And it is funny, some of my kind of OG original buyers back in 2018, they've gotten the best deal ever. They bought something for $250. They ended up getting it as I expanded it. Now I have a SaaS product. They have that access as well. So, I treated them well, but it's hilarious because I had like an owl logo and they still want an owl on everything. They want me to bring back the owl anytime we talk about anything. They all want me to bring it back because they just have these fond memories from whatever that is, 7 years ago now.
So you just brought up the SaaS product. So I was going to ask, like, you started being successful with the online stuff by selling templates. Are you still selling templates today? Like, is your main moneymaker the SaaS product? What are you doing these days?
So yeah, we don't sell templates anymore. Back when ChatGPT first came out, well, let me back up. I always recognized that templates were an imperfect solution. And the reason they're an imperfect solution is, quite honestly, the biggest thing I hear from customers, not the question I get, but the biggest pain point I have heard from the beginning is, I don't know what I don't know about the legal stuff, right? So it is this problem of, I don't even know what to do. And again, I've kind of already said, people don't want to learn it either, right? So they don't want to learn it and they don't want to do it, but they need a solution. And so I had always thought we needed a broader solution, but there really was no way to do it. The rules about the practice of law prevent me from being able to give advice to people one-on-one and answer questions one-on-one, like with particular things. I can give general answers. I can give education. But if you come to me with a very particular, well, here's all the contours of my particular situation, and I answer that, all of a sudden I'm practicing law. And it gets really annoying. These states, basically, because the state legislatures are almost all made up of lawyers, they have laws that essentially say, unless you have a license in their state, you can't do that. Some of them even say to get a license in their state, you have to go and practice in their state for a while. So they're really just trying to protect their local lawyers. But so I couldn't do that. Well, fast forward to 2022, late 2022, ChatGPT comes out. And everybody at that point is talking about, oh, it's going to be great for marketing. It's going to be great for that. And I said, wow, this could actually have some bigger implications for me being able to create a system that could actually answer questions in a good way. I knew nothing about computers at the time, computer programming or how to do it, but that was a spark of the idea. And so in early 2023, I started to flesh it out a bit more. And in April-ish of that year, we made the decision to go forward with creating a SaaS product, which we call Plainly Legal, which has more. We kind of took the templates. There's an agreement generator that does it in a better way. You don't have to customize things. You just answer questions and it customizes them for you, and then you fill in blanks. You can still edit anything you want afterwards, but it does that. But we also built in a legal task manager with an audit that kind of, it asks you questions about your business, and then it identifies the things you need to do. And it prioritizes those things based on risk because, hey, you need to know which are the most important and which ones are kind of like, this is nice to deal with, but you don't need to deal with it right away. And then just within the last month and a half, or month actually, we released kind of the final core feature, which is this chat functionality. We call it Chat Legal. It's trained with a big old database. I have personally either answered or reviewed answers for, I think there's like 700 unique answers in the system, but that's matched up against something like 4,000 questions. And that database is growing over time as people ask more questions. I review it, but it harnesses AI, but in a very tailored way with guardrails, because we feel like, hey, transparency matters. Understanding where this answer is coming from matters. So we built that up, and that's what I'm doing now. And now I'm, in addition to my HubSpot thing, getting HubSpot certified, I'm actually going through a program to get a master's in software engineering at the moment, because why not? I mean, of course, a Harvard Law guy would do that.
All right, so I want to circle back to Plainly Legal in a little bit and talk about some of the advantages that gives course creators, why they might want to sign up for that. But for now, let's jump into some more legally questions. And we started the conversation by addressing that top question you get about people not stealing your stuff. So I'll jump back to some of my clients' questions for you, hitting them one at a time. So Vince asks, scrolling up to the right place, he said, oftentimes we are given the advice to just start. Don't worry, just start, and I know why that is recommended. What would a lawyer recommend for the minimal amount of legal work before or after starting an online course business?
Well, I'm going to echo that. And what I'm going to say is, don't let the legal stuff stop you. Now, I do want to be clear. There are some legal things that if you screw them up at the beginning, they become ticking time bombs, or can become ticking time bombs in your business. So a few things that I tell people are a must, and this is kind of how I shift. Instead of worrying about someone else stealing your stuff, your first kind of inclination, the first things you should do from a legal perspective are kind of like the Hippocratic Oath: first, do no harm. In other words, first, let's make sure you're not stepping on anyone else's shoes. So you have to do a trademark search for the name of your course. That is not something you can skip. You don't actually have to register the trademark. In fact, I would tell people, don't register a trademark until you validated a course, you're going to keep using it, because it's going to cost you some money to do it, and it's going to take at least 18 months to get a trademark. So you got to make sure this is part of your long-term plans. And I can say that as someone who owns like 5 or 6 trademarks for brands I don't use anymore. So you don't want to do that, but you have to make sure that no one else has staked a claim. And, I like to tell people, hey, you could go out and hire someone to do it, but just do a couple things. Number one, go to the USPTO website. So it's uspto.gov. And there's drop downs, and you're going to go into trademarks, and there's a trademark search system, and you're going to search the name you want to use, but also common misspellings, variations. So for example, if you were going to create a course called the Confidence CEO Method, you'd also want to search the Confident CEO Method, right? Because it's just a different tense of the verb, but you're going to search all that through the Patent and Trademark Office, see if anything pops up. You're going to do the same thing on Google or Bing or whatever you want to use as your search engine, but see, is anyone else using it? And what I like to tell people is, if anything close comes up and you haven't launched yet, pick a different name, because it's not worth the trouble. You can always come up with a different name. So that's kind of one that I say base minimum, do that. And I say that because I know a lot of people who have launched a course or launched a podcast or launched something. And what you don't realize is if there is someone who has that trademark, they're not going to hear about you at first. So you're going to spend 6 months, a year building brand equity. You're going to start to get success. And then all of a sudden the trademark owner is going to hear about it and you're going to get a cease and desist letter. And then at that point, you're going to have to rebrand on the fly if it's a podcast. And if it's a course and you got the logo and the name all over your slides, you're going to have to go back and redo it all. And so that's kind of the first thing I say. No matter what, do a trademark search. I suggest to people that setting up an LLC is a good idea. It's not a must, but it's a good idea. And there's a lot of common misconceptions about LLC. Some people think if you set up an LLC, it protects your personal assets 100% in all situations. It doesn't. You're always on the hook for your personal act. Okay, so everyone should understand that. I always like to use the example when I had my law firm. If I, Bobby Klinck, had committed malpractice, there would have been a lawsuit that would have named me personally and Klinck LLC as my employer for that. The same thing's going to happen with your LLC. So that's why I say, hey, get it set up. It's important. It's a good thing. But if it's just you, quite honestly, you're going to be responsible for the most part anyway. So it's not as critical. But that should be the next thing you're thinking about. One other thing, well, a couple other things. On your website, you absolutely have to have a privacy policy. That's not negotiable anymore. The GDPR requires it, but before that, CalAPA, which is California Online Privacy Protection Act, that's been around since like 2003. Now, I do want to tell people, if you're listening to this and you've heard, well, isn't there another California law that came around or some other state privacy laws? You probably heard about those. And what I'm going to tell you is you don't have to worry about them. Those are intended for bigger companies. Almost all of them require that you're making tens of millions of dollars or collecting, for small states, it's like 10 or 20,000 people's information. From California, it's 100,000 residents' information in a year before you're subject to those laws. So don't worry about them. But you do have to have a privacy policy. You should also have a terms of use on your website, which is just general rules of the road for your website and for all your visitors. And then you have to have a course terms and conditions. And that needs to set out, what do people get? What do they pay? How long do they have access to your course? And if you're using language like lifetime access or anything like that in your marketing, you have to be very careful and very clear on what that means. I mean, is it my lifetime, your lifetime? Is it, the lifetime till the end of the universe? I mean, we have to define that. And hint, normally what it is it's as long as the product's online, and if we're going to take it down, we will give you notice and an opportunity to download the material. That's the standard practice. Kind of as an aside, I had that for my templates. Although we took that system offline more than a year ago, I've kept them stored somewhere because randomly people who had unsubscribed from my list will now reach out. And so we still let them download it. We just keep it. It's easy enough. Storage is cheap. So you're going to want to do things like that. But you got to cover all that. Plus, if you have a community, what are some community guidelines? They've got to be nice. They can't be disruptive, but you've got to have a course terms, and you should set up a system where they have to click a box to accept your terms as part of the checkout process. That's how you get that to be a binding agreement. So I would say those are the bare minimum. We could talk about other things that will apply for different people. Like when you have people working for you, you need to have certain agreements in place, whether it's a VA or an employee or anything like that. When you have guest experts, you should have agreements in place. But, those tend to be more advanced things, not things for the beginner.
Before we cover anything new, let me try to unpack a few of the things you've already mentioned. So you started by talking about the trademarks. So your recommendation is when you're getting started, go to this website, uspto.gov, and see if the trademark for what you are proposing exists. That way you know it's worth pursuing. But I think you said that if it doesn't show up, don't necessarily go ahead and register the trademark.
Correct.
Right?
Because here's the thing. You're going to have to spend $350 in government filing fees to get a trademark. Plus, I would suggest that most everyone should at least use a service. There are law firms that do it, but you could also get a service. It'll charge you $100, $150 to file a trademark as well. So let's just ballpark it. You're going to have to spend $500. And if you filed it today, what are we? We're September of 2025, if you filed it today, you charitably would not get your registered trademark until, I would say, February, March, April of 2027, not 2026, 2027. And so I just like to tell people, before you spend that money, spend the time and deal with it, make sure that the course is actually going to succeed. In other words, make sure it's not Safeguard Your Online Genius, where, you try it once, it doesn't work, and you're like, I'm done. Or even, you try it for a little bit and then you decide it's not an important part of your marketing mix, or an important part of your product mix. So I just like to tell people, validate it before you spend the money on the legal stuff, because you're accruing some rights right away. They're called common law trademark rights, which is why I said also do a Google search. But they're limited, right? So, and again, it's really unclear how far these common law rights apply in an online course world. Like in the old physical brick and mortar business, it was pretty clear. Hey, if I open a store in my hometown called XYZ something, I'm accruing rights there in that area, and no one else can open a business with the same name. But how that applies to the online world is not clear. And you're definitely not going to get protection in states where you've made no sales, where you haven't made any real headway. And so you eventually will want to register it if the course is part of success. But again, the last thing I want is for people to feel like they have to wait and do that before they get started. Don't, just get started. And hey, if it's successful and everything's going great. Go to the trademark office, file to register it, and then you'll have your date and you can kind of move forward. But it's just not worth it until you know the course is going to be part of your long-term marketing efforts, is what I tell people.
Well, and next question around that would be, what exactly do we trademark? So let's say we've got a company name, and then different from that is a domain name, and then different from that, maybe our course name is different from all of those. And then we also have a logo, right? Can you trademark logos? Like, which of those are we trademarking?
So you can trademark names, logos, and slogans. There's other stuff. You can actually trademark sounds. Like I think it's the Netflix sound that it makes when you sign on is actually has a trademark. So
do it for us, Bobby. What does it sound like? Go ahead.
Yeah, I can't even think about it. It's one of those things I can't even think about. I think the NBC chimes also is trademarked. Yeah. But again, it's like, okay, let's forget that. So names, logos, and slogans. I tell people, think about it kind of, again, with everything in legal stuff. Let me back up for a second and tell you how a big corporation thinks about legal stuff. They don't think about getting 100% of it done. They're triaging it. They say, I have a budget for this year. I have $100,000 to spend on legal stuff. What is the most important thing for me to do this year? And that's how you should be thinking of it as a business owner. So from the question about, your brand name, your domain name, et cetera. So I like to say, what is the most important asset for you? If it's your overall brand name, that's what you should trademark first. That should be the first thing you do. So again, I actually got a trademark for Your Online Genius, which is hilarious because I haven't used that branding in forever, but I have a trademark for that. But that kind of is your first level. But if your course is your main name, then the course might be the most important thing. I like to tell people, I get why companies like Nike, Coca-Cola, those companies will trademark a logo. You generally shouldn't trademark a logo because, first of all, it's probably not what most people associate with you. It's the name is what they're going to care about the most. And so you're generally going to want to do the most important names and kind of, you have to do this internally and figure out to yourself. And I'll just ask it this way. Which one would it hurt you the most if someone started using the same name or a confusingly similar name? And you have to figure that out for your own business. And then you go down that route. And then that would be the most important thing to start with. And you can kind of work your way down.
Hey, it's Jacques. Real quick, I want to tell you about my free workshop on launching and growing your online course business. This training gives you a simple step-by-step system to validate your idea, build a sales engine, and make those first or next sales. Join for free at oc.show/workshop. Once again, that's oc.show/workshop. All right, back to the conversation with Bobby. So you also mentioned some legal pages or agreements that we need. You said privacy policy, terms of use, and then the course terms and conditions were the main ones, right? So if I understand it correctly, the privacy policy terms of use, those would be some things that are linked in your footer of your website,
Yes, that's
whereas
right.
the course terms and conditions would only appear as a checkbox on the checkout form?
So you're going to do the same thing with your course terms that you do with those legal policies. You're going to just create a page on your website that houses them, but you're not going to link that generally on your general footer for your website. You're going to put links to that on your course sales page. So wherever someone could do it, for example, you want to put what your refund policy is on your sales page in a more plain English way. But depending on what it is, like if you have anything that is anything other than no refunds or 30-day no questions asked type of refund, if you have any kind of limitations or things like that, you're going to want to kind of summarize it on your sales page, but then you're going to want to put a link that says, read more about it in the refund policy on the term. So like you'll put it there as well on your course sales page. Then on the checkout page, you'll link to it. Then once someone has agreed to it on the sales page checkout or on the checkout process, they're bound by it. But it's also a good practice to include a link within your course materials somewhere, if possible. And you could go a step further and include it in the email confirmation you send to people when they join your course. Again, you don't have to, but that's another thing that some people will do as well. But the terms themselves will generally live on a website, on a page on your website. You could create a PDF as well and send it to people, but it's ultimately going to be something on your site somewhere. It's just not linked everywhere on the front end of your website for the most part.
We're talking about legal here. This is not my forte. Some of the questions I ask might be a little dumb or silly, and I feel like this next one might fall into that category. But like, okay, let's say we set everything up perfectly, just like you're talking about, and people have to check this box in order to check out and buy the product.
Yep.
And what you said was like, once they check that box, they are bound by that agreement, right?
Yes.
But like, really, like, how enforceable is that, right? So like, if they're agreeing that the refund window is 30 days, and they're like, hey, on day 33, they're like, I'm getting out. I don't care what you say. I'm gonna dispute it, and I'm gonna take my money back. It's like, is it really worth chasing after the $300?
Well, so a couple things. What I like to say is, the chargebacks and disputes, that's one of those things that is a real pain. It annoys me that people do that, because let's be clear, when they do that, they are committing fraud. I mean, if they honestly did buy your product, you delivered on it, and then they're disputing it somehow, they're committing fraud by telling the credit card company that, or PayPal, or whoever you use. But let's be realists. The credit card company's incentive is to side with their customers, not us as the sellers. That's the reality. What I'll tell you though is if you do things right and you document it, you can document that they purchased it, that they accessed it, that they agreed to the terms. You will have a much better chance of succeeding when you oppose a chargeback request. Now, I'm going to tell you, even with that, you're not going to win 100%.
Clarify. Yeah, so chargebacks to me is like a whole different category. I think what I gave you was a bad example. Let me try to give you a better example. Let's say that we're offering, we have a $500 course, and you can either pay one time for $500, or you can do 6 monthly payments of $100.
Yep.
And they select the monthly payments, and they've made 2 of their monthly payments, and then they've stopped making their monthly payments, even though they checked a box agreeing that they would make 6 monthly payments. So
Yep.
this example has nothing to do with chargebacks.
Yep.
Technically, they're on the hook for 4 more monthly payments.
Got it.
What do we do? I mean, my advice is like,
let it go.
There's not much we can do, right?
Yeah.
So if that's the case, why even have the checkbox?
So here's the thing. You're right. I generally would not pursue those people because, I mean, first of all, some of them are doing it in a malicious way of, well, I don't like this. I'm going to literally, cancel that credit card or do something, But for the most part, when those things happen, it's actually, their credit card expired, or their credit card declined the payment because they'd hit their credit limit or some other reason. And I'm with you. I don't pursue it. And part of the reason is there's really complicated rules here. Technically, you got to be careful that you're not offering credit, right? Because we are not banks. We're not allowed to offer credit to people. And so that does put some limits on things. That means you probably can't pursue it. Like you can't necessarily send it to a collections agency. I mean, you could sell this stuff off to a collections agency, but they're not going to have a lot of threats because they can't ding the people's credit report. They can only sue them to pursue this, and no one's going to do this. The reason to do it is actually kind of the impact it has on people psychologically as much as anything else. What I'll tell you is true bad actors, you're never going to stop with agreements. And people who are being malicious, you're never going to stop. Maybe I'm Pollyannish here, but I believe that is the vast minority of people. And if you have an agreement with them and you say, look, we had this agreement, you've agreed to this, we've already provided you value, I believe that 90% of people will follow through or at least aren't going to do nefarious things like cancel a credit card or do something like that to avoid making those payments. So there's some of those benefits. Some of the other reasons you want to have those agreements have nothing to do with payment, quite honestly. It's about limiting what they can do with things. It's about putting limits on and making clear what they can and cannot do with your course material. So that, again, if there is an issue, and some of this is complicated, if you don't register a copyright for your course, you can't sue someone for copyright infringement. You have protection. They're not allowed to do it. They're not allowed to copy your course and do it. But if you haven't actually registered, you can't sue someone. But if you have a contract clause in your terms that says they can't do that, then you have a protection there as well. So it's, again, this kind of belt and suspenders. You want to make sure that you have those protections. But what I would say is having the agreements is incredibly important separately for things like chargebacks. It's also important for, sometimes the terms of your payment processor may require you to have certain agreements in place. And so think of it as part of an overall whole and making it kind of doing the best you can given the realities of this world.
So just to be clear to you and the audience, I'm not advocating to not have the checkbox. I'm just asking the question for.
And let me give you the listeners really the most important reason in a lot of ways. One clause that every course term should have, if you're in the US at least, you should have an arbitration clause that basically says any disputes will be handled through arbitration, not through court. And it says that it has to be individual, not class arbitration. That is hugely important because it effectively means if somebody got mad without that clause, and again, it's probably not going to happen, but if you got big, they might say, well, I'm going to sue you, and I'm not just suing you on behalf of myself. I'm suing you on behalf of all of your students. And so they're going to it can make it where it might not have been worthwhile for them to bring a dispute against you or to bring a case against you individually. But if they can do this class action, which again is basically a way of saying, I stand up and say I'm representing everybody like me and I can actually recover damages which have to be paid to them, but it makes it worthwhile for lawyers sometimes. If you have an individual arbitration agreement, that never happens. So it basically just means you're not going to have disputes. Your students won't ever come and complain because it'll never be worth their while.
You mentioned the word copyright a minute ago. What's the difference between trademark and copyright?
Okay. Trademark, all about branding. So trademark is about identifying the source of a good. So Nike, swoosh, just do it. Those are all about, so the concept is when you see the name, you see the logo, you as a consumer can make judgments. Like we all have opinions about Apple. Maybe you like Apple products, maybe you don't like Apple products, but that way you don't have to do detailed research about everything. You can say, okay, this is an Apple product, so here's what I think about it. That's what trademark is. Copyright is what protects your content. So every piece of content that you create in any way, shape, or form that has any bit of originality is protected by copyright. Your course videos, your worksheets, your blog posts, your podcasts, all of it is protected by copyright. And it's protected automatically as soon as the material gets into what's called fixed form. Fixed form basically occurs as soon as you create it. So like a video, as soon as it's created, that's fixed form and you have protection. The problem, like I said, is that under the law doesn't make sense a lot of times. You can't actually sue someone until you've registered it. But that's kind of the distinction. I think copyright is about content, trademark is about branding.
I have only really gone over one question from the clients, and we've gone on to all these amazing tangents. So let me kind of jump back. This next one is similar to the one I already asked you about, what to look for when you're getting started. Jason says, what is the most common mistake digital entrepreneurs make that, while relatively easy to address early, may be challenging to tackle later?
Okay.
And that may be something you've already brought up.
Yeah, I mean, I would think trademark is one of the big ones, because once you've done that, it can become a problem. But really, it's anything that you do that bakes a problem in. And in this one, I'm going to be slightly different, and I'm going to talk about going back to the story of how I had that breakup with those two lawyers because we didn't work out the agreement in advance. So anytime you're going to be working with anyone else in any context, you should work out the details up front. The easiest way to do that is to create a written agreement because it forces you to kind of really work through all the details. There's a classic example. I don't know if you remember Adam Carolla or if your audience will, but he was a comedian. He had a podcast, which at one point was the world's most popular, most downloaded podcast. He created it with a friend of his, like, was the producer, helped him get it off the ground. And at some point after it had become one of, if not the most popular podcast, which again, this is dating because that was a while back, a dispute came up. And he basically said he was firing his friend. His friend said, what do you mean you're firing me? I'm an owner. I'm a partner in this business. And they had zero written agreements that set out anything about that relationship. Now, I have no idea how it would have turned out, how it should have turned out, but they ended up in a lawsuit that lasted 18 months. And they must have spent millions of dollars on lawyers' fees because they just didn't get a written agreement at the outset. So get the things in agreement, get any agreement you have that would matter in writing at the outset, and work out all those details at the beginning.
Next question is from Michaela. She has an in-person pottery business in Mississippi and is trying to do some online courses around that to reach a more global audience. She says, someone started a business across the country with our exact name minus the S and our exact logo, doing the same exact things as us, even down to wording their website similar to ours. If they start doing courses, would it be any benefit to us to try to get them to cease and desist?
So the first question I would have is, do you have a registered trademark? Because if you don't have a registered trademark in your name, the fact that they are, and again, I assume this is talking about the actual kind of brick and mortar part of the business is what this other business is what it sounds like. This is where the geographic limitations are probably going to mean you're going to have protection where you are if you didn't register it with the patent.
Let's assume that they don't have a trademark in this case.
Yeah. If that's the case, here's what's going to happen. They have rights to use it where they are, and you have rights to use it where you are. And if that's the case, your course really needs to have a completely different name, or you're not going to be able to get a trademark for it realistically, because their existing usage could prevent you from getting a registered trademark down the line. So this is where it gets complicated. And there's not a great answer, but especially when people are branching out from kind of existing brick and mortar businesses, this becomes an issue quite frequently. And in that case, maybe you can't get your brand trademark, but you could get a trademark for the course name and pick a name that would be different enough to get a trademark on the course name. And at least that'll be protected.
She actually asked 3 questions, and that was the third one. The first one was the one I actually read earlier about like safeguarding from people stealing.
Yep.
So I'm not going to re-ask you that one. But the second one I'll bring up, and maybe you've already addressed this. You can let me know. But she's saying, what rights do you actually have to intellectual property if you don't file a patent or trademark, and is it worth it? So I feel like you kind of addressed that. I don't know now that you've addressed one of her questions, if there's anything to add there.
Yeah. And so just since we haven't talked about patents, just so what people understand, patents are the only form of intellectual property that protects ideas. Basically, they protect an invention is what a patent is about. And so it's generally not really relevant in our world. In my world with SaaS, you can get a patent for software, but they're rarely enforceable. But in an online course world, you're not going to have patent issues. So trademark issues are there. And this is where I come back to, you get some rights automatically in trademark, but they're limited. Whereas if you register a trademark, you get nationwide protection. In addition to the nationwide protection, you get a presumption of validity. You get a presumption that you own it. You get all of these different rights that can come up. But again, so this is where it's a hard thing. You have to decide, is it worth it? And it's most important for your brand, which unfortunately it sounds like in her case, that's the thing she probably can't get trademarked. And you want to think through these things early on because it does provide some value to you. I like to say that our businesses are really 100% intellectual property. That's all we have. I mean, sure, I've got some computers, I've got some equipment, but at the end of the day, the value in our business is our knowledge, our expertise, our brand, all of those things. So it is important to understand that stuff, but, don't go overboard. Don't feel like you need to, trademark every slogan. I mean, I almost, in a previous life, I almost started a beer company and I actually registered a trademark for a couple different slogans for a bunch of different stuff before we even started. Again, I have shelves and shelves of trademarks that, I've spent $500 on that I don't need at this point. So there's always kind of a balance there.
A lot cheaper to collect domain names than trademarks.
Oh, yeah.
All right, next up, Sean says, for healthcare workers providing general advice, not prescribing, what steps can be taken to protect ourselves in addition to disclaimers on videos and content? Should we carry liability insurance for online content just in case? If so, where would you recommend we look for this?
So yes, a couple things I would say. First of all, if you have a professional license of any kind and you're practicing that profession anywhere, this is one place where I say you should set up a different LLC at the outset for your online business. So when I started my online business, I still had my law firm, Klinck LLC, but I set up Your Online Genius LLC to house it and different websites. So it was very clear. Over here, this is where I'm providing legal advice. And over here is where I'm providing legal information and guidance and courses. So that's number one. Make sure you have the corporate kind of structure separated. But yes, in that case, I would recommend insurance. Now, again, insurance is one of those things. Really, it comes down to your own personal risk tolerance. I don't know a lot of people who've been sued for giving bad guidance in the online world. But some people just don't want to take any risk. It would just eat them alive. If that is you, you should make sure to get insurance. I have heard from people that Next Insurance is one, Hiscox is one. There's a few different places, and what you would be looking for would be errors and omissions insurance. Generally speaking, is what you would be talking about for kind of not advice, but advice. If we say for giving guidance, if that's incomplete and it hurts someone, there's a couple of other things you could get, like cyber insurance, which is more about if there was a hacking of your system. General liability might cover you in IP disputes, but the errors and omissions insurance would be the kind of first level. If you wanted to get one type of insurance, that's what you'd be looking for.
Okay, I think that's going to do it for the questions from the community.
Okay.
All right. So let's go back to like the privacy policy terms of use. You mentioned linking to those in the footer. All right. This is more one of those like Jacques dumb, silly questions. But like, if you don't have that, so what? Like who's gonna catch you and what would the penalty be?
So what I would say is the terms of use, first of all, that is purely a best practice. You're not going to get in trouble there. What I suggest to people for a terms of use, part of the reason you want to have that, if at some point you start selling something other than a signature course, whether it's a little kind of a self-liquidating offer at the beginning or little PDF books or things like that, you're not going to want to create different terms for each one of those. So your website terms would have a background refund policy that would just apply to all those things, for example. So that's part of the value there. And you would use a checkbox just like you would use on a course for those types of things. Now, your privacy policy, I would like to tell people, look, there are not GDPR police, but there are GDPR police. I mean, there are authorities in Europe who theoretically are monitoring this and could come after you. Are they coming after you? Are they coming after me? No. I mean, they're busy going after Facebook and Google and the big people, not us. But people could complain. But I do like to say, if you ever want to advertise on any one of the social networks, they will require you to provide a privacy policy. You're going to have to link to it and show them that you have that. A lot of some and I shouldn't say a lot, but some of the payment processors will require you to have a privacy policy in place. So you're going to need those things separate from the legal issues. And also, I like to tell people, quite honestly, it's just, it builds trust. I mean, I don't know about you, but there are some things when I go on a website, if things are just missing, it can make me wonder about whether I want to do business with a company. Not that I go and read people's privacy policy. I mean, I did back in the GDPR days, but I don't go and read privacy policies these days. Some people do, though. And having one will build trust and will show that it actually matters. Same thing, or related thing. Website accessibility. This has become an issue lately. Under the Americans with Disabilities Act, there's a thing that says places of public accommodation must be accessible to people with disabilities. Well, me as a lawyer, I never would have thought that applied to websites for things that don't have physical locations, but courts have disagreed. And so now we have to do that, which is fine. I'm all for it. Let's make it accessible. And people would always ask me about accessibility statements. You don't need one. There's no legal requirement to have one. I have one on my website because I want to show to people that this is something I'm thinking about, I'm caring about it, and I'm trying to make sure that my website is accessible. Because it's one of those things. I mean, you could call it virtue signaling, you could call it whatever you want, but it will have some positive impact for some potential customers. So there's a business reason to do it separate from the legal stuff.
All right. So sticking with this theme, at a bare minimum, you mentioned we need privacy policy, terms of use, of course, terms and conditions for various places across our website and whatnot. If I'm listening to this and I need those or I need to revamp them, any reason I can't just open up ChatGPT, hey, I run an online course business teaching piano, drop me off a privacy policy. Is that the best way to go about getting one?
So it's not the best way, but I do like to tell people, I always like to tell people, I'm a realist and I want to talk to you in levels of good. The best solution is to go work with a lawyer who is specifically entrenched in all this stuff, works with your types of businesses day in and day out. And I want to stress this, understands all of these things. I mean, they deal with all of these different issues because you have to understand most lawyers don't deal with the different issues that we face because it's kind of a weird mix of things that online businesses face. But if you can find a lawyer who does that and work with them directly and get them to custom draft an agreement for you, that will be the best solution. But it's going to cost you a lot of money. We lawyers are expensive, and so that's one option. A step down from that is going to be either paid templates or something like my SaaS product, where a lawyer has created it, and there's a lot of thought that's gone into it, but it makes it accessible because it's something that's not done, specifically. Level down from that would be probably ChatGPT or something like that. But I will tell you from testing out our chat system that the chat systems, they get some things wrong. Earlier, I mentioned the LLC doesn't protect you. If you ask questions, like ChatGPT would give you the impression that having an LLC will protect you from from getting sued for bad advice. It won't, because you're on the hook for that. And, so as I've developed our product, I've had to very clearly put those guardrails in. But again, that's definitely better than nothing. If your option is nothing or ChatGPT, go with ChatGPT. And another option is, hey, I would say, in privacy policy, like these kinds of things, you would never do this because, it's kind of weird. But, for a normal agreement, I'd say, if you're just doing it, if you and I were doing some kind of joint venture, some kind of agreement, just write it down in plain English on paper. And that's better than nothing, but it's not nearly as good as all the others. So it's kind of that levels of good and where do you fit and what can you afford and what can you kind of think about? I don't think most people actually should hire a lawyer. And again, I'm not supposed to say that, but for the most part, it's just not worth it. Forget legal perspective, just from a business perspective. When does it become worthwhile for you to spend $5,000, $6,000, $7,000 for legal stuff? Not at the beginning, that's for sure. Most people just don't have that kind of money, and I wouldn't recommend it to. I mean, the funniest thing when I first broke in to the online world, after my failed launch, before the kind of Amy Porterfield thing, I was in this course or joined this program about creating a high ticket program. And it was dumb. I mean, I didn't need help creating a high ticket program. That's what legal work is. I needed help making it affordable and accessible, kind of the opposite way. And so, that's the way you need to think about it is kind of what can you afford and get that level of protection.
So look, I was trying to tee you up a little bit to just say, oh, plainly legal, like that's the way you should go. And I love that you didn't just go straight to your product. You gave the different tiers And you specifically said, I think, like levels of good, which I
Yep.
think was a cool way to put it.
Yeah.
But I do want to talk about plainly legal.
Yep.
Please, if you could talk about like who it's a good fit for. And when I go to like the sales page, there's 3 different levels, and
Yep.
talk us through like which level is right for which people.
Yeah. So our pricing right now, well, let me start up. Like I said, our core features now, you kind of have 3 core features: agreement creation. So that's agreements, policies, letters. I mean, we even have cease and desist letter drafts in there you can create. So we have a lot of different things in there. We have the audit and task manager, and then we have this chat functionality. Right now, our pricing is based purely upon how many agreements and legal policies you want to create. And to answer the question, we kind of have a pay-as-you-go option, which I think it is. We charge you a fee to be part of the system, to have access to the things, and then to be able to create agreements. With that, we'll give you 1 credit to create an agreement off the bat. It's $197 a year for that option, but that's kind of, hey, I want you in the system so that you're using it, so that you have access to the chat, so you can kind of get those things and help yourself along the way. And then you can decide, hey, I need another agreement, so I can go and buy another credit if you need to. Then we have a mid-tier where we call it the kickstart. We have a setup fee. It's not really a setup fee. Basically, what you're doing is buying a package of credits right up front. So you'll get 5 credits when you sign up, and then it's for about $500, and then it's $47 a month, and you get an additional credit each month, and they roll over, and you can keep building up as necessary. So if you're going to be doing a lot of stuff and going to have agreements that you might need over time, that could be a good option. The final tier is our unlimited plan. That really is right now perfect, probably not for course creators. It's more for people like coaches, service providers who are executing a lot of agreements every month. So they really need to just be able to generate agreements on an ongoing basis. Now, in time, we're going to add other features. I have goals to add things like trademark search and those types of things, and we'll have certain tiers. The next thing I'm working on, candidly, is an e-signature built in. So you'll be able to send agreements out for e-signature, which will kind of get built in. But what I tell people, don't just guesstimate what you need to do. Sign up. Right now, you can sign up for a free account. And when you sign up for a free account, you can get in and do the legal audit. And it will literally create this list of all the different tasks. And it, like each one, if it's an agreement, it'll tell you it's an agreement. So you'll kind of know and be able to say, oh, okay, according to this. And you can say, oh, I've already got that one, or I don't. But then you'll have a number. Do you need 1 agreement? Do you need 10 agreements? And you can kind of decide from there which option makes the most sense for you right now based on where you are.
Amazing. All right. So in my little outro separate from this, I will tell people exactly where they can go to sign up for either that free account where it's very limited, or for one of the paid tiers. And you have generously offered to give the audience, I believe, a 25% discount when they use the link.
Yeah. So it'll be a
So
25%. It'll be, you'll have a coupon that you'll be able to give people, get them 25% off perpetually. It's software, so it's a subscription, but you'll get it off every payment going forward. With this, it'll just be part of your system. When on your kind of base subscription and any renewals, you'll get that 25% off.
Amazing. Thank you for doing that. I'll share with the audience in just a couple of minutes how they can take advantage of that. Last question for you is pretty general. I started by asking kind of the most common legal question. Now that we've been talking for about an hour now, any other like obvious legal type questions for course creators that we haven't hit at this point?
Yeah, and it's something your audience may not like. So it has to do with what material to include and not to include in your course, in your marketing, and all those things. And it used to be, before memes and GIFs became everything, the problem that I would have every time I went on those podcasts starting in 2017 and would talk to people, every host would want to talk to me about their Getty Images letter problem, which was essentially meant either they knew someone or they had gotten a letter from Getty Images saying, well, thank you for using our image without a license. That'll be $5,000, please. Because what had happened was I called it the right-click save as problem. Someone scrolling the internet, sees an image they like and says, ooh, right-click, save as, and then they use that somewhere. You can't do that. All images that you see online, they are protected. GIFs, they are protected. Memes, they are protected. There was a famous case of these 2 women were running a Facebook group for something, and like there's a famous meme of it's a bunch of levels, like levels that you would use in construction that have the word wrong written on them. And so it's like wrong on so many levels or something like that. And the person who created that sued them for copyright infringement and was like seeking hundreds of thousands of dollars in damages because their post went viral. And so I just tell people, don't do it. Don't use memes. Don't use GIFs. I mean, again, when you're on a social platform, if it's built in, if your account is appropriate and you've told people it's a commercial account, et cetera, if they let you use GIFs, use it. Because I'll tell you, the Facebook lawyers, they're not going to let you use it if they can't. Same thing with TikTok, same with all the different socials. But definitely don't go grab those things and use them elsewhere, whether it's in your course, in your emails. It's just not worth the risk, because those are the types of things that, there's a little bit of added value, but it adds a lot of potential risk. So just avoid that stuff at all costs.
Cool. Bobby, it's been a pleasure. Thanks for joining me today.
Thanks. Been a lot of fun.
All right, I really hope that you have enjoyed this episode. Now, I'm not going to say that you have to sign up for Plainly Legal, because that's the only way to get your legal stuff in order, done right. But for those of you that want to hit the easy button on getting things like those documents in place, like your privacy policy, your terms of use, and also have a place to ask legal questions, then Bobby has graciously offered 25% off for you all. So to take advantage of that, head to oc.show/legal, oc.show/legal, and make sure you enter the promo code OCG25. That's what will get you that 25% off. So once again, oc.show/legal, promo code OCG25. You can find that link and any other links or resources that we mentioned here in this episode by visiting the show notes for this episode at oc.show/268. And I told you earlier about my free workshop. It is a 35-minute training, no fluff, and it is free at oc.show/workshop. It's my best and latest training on exactly what a successful online course business looks like. Once again, that's oc.show/workshop. Thanks again for listening. Don't forget to take action on what you've heard here today. I'm rooting for you.